An inherited home being sold 2 years after death. Are the capital gains taxable to the estate or the individual beneficiaries? Now, this seems like a simple question, but there are definitely some nuances here that we should review. Before I get to that, however, I'd like you to imagine a friend going through a challenging what-if scenario that creeped into their lives, but they were prepared because you shared this video. We'd appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Now, it should first be noted that an administration can take up to 2 years or that thereabouts, sometimes longer, depending on the complexity of the circumstances. I would say the average is 18 months to 2 years, but that's not unheard of. So don't think 2 years is a really long time for an administration to be ongoing. However, the sale of real property sometimes will take that long and sometimes not. In your circumstance, obviously it has. If the home has not been distributed to the beneficiaries as of yet, it is being sold under the estate. And thereby, there should be a tax return for a fiduciary, what we call fiduciary income tax return, done by the executor, personal representative, however they're designated, in reporting that sale when the next, April comes around. Although, just as a quick side note, sometimes a fiduciary income tax return, that for an estate or a trust, can be done on what's called a fiscal year, usually from the date of death to the end of the month prior, if that makes sense. So if someone passed away on today is July 10th, it would go from July 10th through June 30th of the following year. Anyhow, that's a side note. But when it comes to reporting the sale under the estate, it's extremely important to understand that if it is the final tax year for the estate, because there's no additional income accruing in any year thereafter, then the income tax consequences and even the deductions, if there are any extra, will flow through to the beneficiaries in what's called a K-1 statement. That's typically preferred because the tax rates are much more progressive for an estate or a trust, and you'd rather pay that on a personal level, which will save you a few dollars in the long run, typically. One tip, though, is if it is a final year and the distributions are being made out to the beneficiaries, and so they're receiving a K-1 from the estate to show the income, as well as any deductions, you have to make sure the beneficiaries are aware of this so that they can, if necessary, file an extension for their personal returns if that K-1 has not been received yet. I hope that information was helpful and that you learned something new here today and that you choose to share. We hope you have a great one. Take care.